Hello and welcome to this week's session of ELI's Summer School Basics of Land Use and Energy Law. My name is Chandler Randall and I'm the Manager of Educational Programs here at the Environmental Law Institute, and I am so delighted to welcome everyone to this special webinar. ELI is proud to offer programming on cutting-edge issues in environmental law and policy, and it is such an honor to have you join us today for today's program. Please join us each Thursday this summer for summer school sessions, such as this one covering key topics in environmental law. At the end of today's webinar, we will have time for a Q&A session, so please submit your questions through Zoom's Q&A box, and please do not wait until the end. Send us your questions as soon as you think of them. I would like to thank our outstanding panelists for joining us today to lend their expertise to this webinar, and while they will be introduced briefly, their full speaker bios are posted on our website, eli.org, and I strongly encourage you to check out their expertise and experience in more detail there. But as we begin, I would like to very briefly introduce today's panelists. We have Mason Imnant. Mason is Senior Vice President of Public Policy at Constellation Energy Generation, LLC. Mason oversees the development and implementation of federal legislative and regulatory strategy for Constellation, the nation's largest producer of clean energy. Prior to joining Constellation, Mason oversaw the development and implementation of federal regulatory strategy for Exelon Corporation. Mason has also held roles at NextEra Energy, FERC, and in private practice. Thank you so much, Mason. We're so glad to have you with us. And up next, we also have Heather Delapolowski. Heather is a partner at Wires Gills, LLP, where she works on all matters of land use and zoning issues for projects, including mixed use, multifamily, and commercial properties, Her clients have included commercial and multifamily developers, institutions, and churches, among others. She has extensive familiarity with complex zoning and subdivision regulations, as well as related laws such as those concerning moderately priced dwelling units. Thank you both so much for being here. We are so thrilled to have you with us today. And with that, I will turn things over to Heather to get us kicked off with land use issues. Thank you both so much.
Great, and I'm just requesting control of the screen. Mason, you can thumbs up, you can hear me okay? Got it, great. Okay, and I have control of the screen. So thank you, everyone. I'm so happy to be here. I think this is my third time doing this in the past 4 years, and really enjoy it. And look forward to presenting to you. But frankly, I think actually the Q&A at the end is more fun. So definitely, as Chandler said, submit your questions, and we look forward to discussion. Again, my name is Heather Delapolowski. I have been a land use and zoning lawyer in private practice, basically straight out of law school. So I think it has been 16 and a half years now, if I'm doing my math right, that I've been in practice. And since I know probably folks are joining from all over, I presume all over the country, I'm in the Washington, D.C. area, and I'm in Maryland, actually. So I'm a Maryland practitioner, and I focus on Montgomery and Prince George's counties, just because, as you'll hear, land use and zoning law is highly local, very highly governed by the exact jurisdiction that you're in. So we can only do so many. And Montgomery and Prince George's counties are fairly urban, but have suburban and also rural areas. So just wanted to give that context for anyone who's not familiar with this physical area. So first, I just wanted to talk a little bit about the fact that I think when we hear land use and zoning and development, developers, we often think, oh, these commercial for-profit developers, the people, putting up high rises near metro, or, building subdivisions out in the undeveloped lands in the far out portions of counties. But really, land use and zoning affects so many different people. So these are actually just a smattering of folks that or different types of businesses and institutions that I'm actually actively working on right now in my practice. So, bakeries, if they own land, or even if they want to just rent a place, they need to make sure their use is permitted and they fit within the development standard. Churches, one thing we're seeing a lot is, some like smaller churches, or maybe churches, ethnic type churches who were renting space, they want to own their own land. And so they have to encounter development issues in land use and zoning. Nonprofit organizations, service organizations, groups affiliated with universities, services like Knights of Columbus, they encounter these types of issues. Warehouse, obviously, we're all very familiar with e-commerce. They need physical space to do their business. Affordable housing developers, which certainly in Montgomery County has actually really been very strongly encouraged and pursued by a lot of folks right now, which is great because we need more affordable housing, but they still face, even though they're not for-profit developers, they still face land use and zoning issues. And then of course we have folks like our commercial developers, gas stations. Someday maybe we won't have them anymore, but we still need them now. And cemeteries. I actually represent a few cemeteries too, and they have their own unique issues. So again, it's not just the commercial developers, it's all sorts of folks who encounter land use and zoning. And I want to say too, so this presentation will actually be very much focused on daily practice of land use and zoning. There's obviously significant constitutional and case law underpinnings of land use and zoning law, which I will not be speaking about from sort of the academic perspective. To be perfectly frank, I have never taken a land use or zoning law class in my life. I just sort of came into this and I very much learned by daily practice. So I'll just give a little bit of this sort of fundamental underpinning overview, but that's probably about the extent that I can speak to it. And I'll be really focused on just the day-to-day nuts and bolts of how I help folks with land use and zoning. So land use and zoning authority is derived from the police powers, and at least in Maryland, which is again where I practice, the police powers are given to counties and municipalities under Maryland law. And the police power is the power to establish laws in furtherance of public health, safety, and welfare. Obviously an expression and a phrase that I'm sure folks are familiar with. Land use and zoning law is highly locally regulated, as we'll continue discussing throughout this, but there are federal and state aspects that impact that. And so you have things like, preemption of local laws, things related to medical cannabis, which is actually obviously a very big topic these days. Of course, the Americans with Disabilities Act, Fair Housing Act, what's called RLUIPA, lots of consonants, lots of letters there, but basically laws related to religious land use. So land use and zoning is very, very local, but there are elements of federal and state that sometimes come in and impact projects, wetlands, that sort of thing too. Okay. And again, I will be speaking more specifically to Maryland just because that's what I'm familiar with. So you'll see that come out throughout the presentation in Maryland, but frankly, I think in general, the specific powers granted depend on what type of sort of governance of the jurisdiction that you're in. So to the extent that you're in a county, there are various forms of sort of county government. So are you a charter form of government where you have a county council and a county executive, or county commissioners where there's no executive? And under Maryland law, there's actually different types of laws that are granted depending on what type of county you are. Some have authority to do things, others don't. And then you might have the authority to take something up if you're a county, but have you taken advantage of that authority? So for example, some counties under Maryland law have the ability to impose mandated affordable housing programs. Some have, Montgomery County has, others have not taken advantage of that authority. And then another thing to keep in mind, and this is funny for me because I'm from Long Island originally, and I'm very much used to, everywhere sort of in the North in general is a incorporated municipality. So like you are always within a town or a city. Whereas, for example, down here in Maryland, and I think largely in the South, there are lots of areas that are unincorporated. You're just in the county. So it's very important from a land use and zoning perspective to understand if you're just in a sort of unincorporated area, and so it's the county land use and zoning regulations that apply to you, or if you are A, in an incorporated municipality, and then B, does that municipality have land use and zoning authority? Because you might be in a municipality, but that doesn't mean they have land use and zoning authority. They may just be, code violations and that sort of thing. So very important to understand where you're located and then what authority that area has to govern your land use and zoning, because it can be very different. I've had but I've come into matters where someone analyzed what's allowable on a site based on county laws. And I said, well, you're in a municipality and they have their own laws. And so now we have to redo all of it. So very fundamental thing to understand. Types of powers, we'll just run through this very quickly because we'll talk about it in more detail. So there's sort of a big difference between land use / planning and then zoning, and we're going to talk about that difference. And then there are also things which I'm sure you've heard about in your dealings. Subdivision, I think we all sort of have an idea of what that is. Adequate public facilities, making sure that things like schools, fire, rescue, or adequate to serve proposed development, affordable housing, obviously, historic preservation, and then other sorts of adequate public facility issues like planning for streets and roads and planning for water and sewer. So as I mentioned, there's a very fundamental distinction between planning and zoning. We're going to talk about that. So planning, I think we can talk about planning sort of big picture, sort of qualitative. So county and city planners create policies to encourage development that will serve the needs of the public in the future. And I think the key term there is policies. So this is very broad. This is long term. It guides land use. It doesn't mandate, it guides. And planning is typically advisory. It typically does not have the force of law. Planning is not a law per se. And we can sort of put a pin in that because there are some instances where whether substantial conformance to the planning documents need to be found for approval of certain applications. But in general, planning is broad, advisory, policy, guide. And then zoning is more specific, more binding, essentially. And you can see there from Rathkopp's The Law of Planning and Zoning, what zoning is. And zoning, it is property specific. Every property, at least in this area and through most of the United States, has a zone. It is located in a very specific zone. That zone is identified on the official zoning map for whatever the jurisdiction that controls that area is. The permitted uses and the development standards applicable to that zone are in either the county code text or the city code text if you're in a city. And zoning is binding. It's not merely advisory. It's not just a suggestion. It is the zoning of your site, and here is what you're allowed and not allowed to do with it. So now we'll just go back to planning briefly and talk about types of land use planning actions. So you can familiarize yourself with that a little bit. They come under many different names, and you'll see different names based on the jurisdictions that you're in. But usually it's land use planning. It's a plan. So that's a good hint that you're dealing with planning as opposed to zoning. Something called a general plan. Usually that's something that's applicable to an entire county. So like Montgomery County has a general plan. Prince George's County has a general plan. Master plan typically then is a something smaller area. So if folks are familiar with sort of suburban Maryland, like Bethesda there's a master plan for Bethesda. There's a master plan for Silver Spring. Sector plans, again, getting a little bit smaller. Maybe you have a sector plan for downtown Bethesda as opposed to broader Bethesda. So, sort of drilling down a little bit more. They're still all planning documents. It's just sort of a matter of geographic scope. But then switching away from geographic, you can have something called functional plans. And these, again, are still planning actions. And functional plans can cover so many different things. So here's just a few examples on the screen: a functional plan for transportation, a functional plan for the environment, a bicycle master plan, parks plan, historic preservation plan. In Montgomery County, there's even a rustic roads plan that deals with the rustic roads in the northern area of the county. And these functional plans seem so highly specific, and they are, but they are super important. And so if you're ever looking at buying a property, if you're representing someone who's looking at buying a property, if you own property or representing someone who's looking to see what they can do with their property, follow these functional plans. It sounds like a lot of time and effort, and it is. But for example, you can see here, bicycle master plan. Montgomery County adopted one a few years ago, and it's great. Bicycles are great, especially in this day and age of $5+ gallons of gas. I ride a bicycle all the time. But Montgomery County is proposing bicycle lanes across many roadways in the county. And if you're looking to redevelop your property, you would be tasked with implementing that master plan recommendation, or at least in any case, paying for it. Even if they're not planning on implementing it now, you pay your pro rata share. And these bicycle lanes, and they're not paved in gold, they're regular bicycle lanes, are tens of thousands of dollars, if not more. So pay attention to those functional plans. They're very important, even though they may seem highly detailed and specific. Just very briefly, trends in planning. For example, Montgomery County has recently just redid their general plan, and I stole this image from their general plan, and just wanted to put this up on the screen because you can see things that they talk about and consider as part of that planning effort. And I think a lot of these terms are ones that we are certainly familiar with, especially in the past few years. Equity, affordable and attainable housing, environmental resilience in the age of climate change, and sustainability. So there's a lot of things that go into land use and zoning planning that are not just pure land use and zoning. There's a lot of societal factors that are taken into account as well, especially certainly so in recent years, which I think is a good development. So now we're going to be drilling down a bit into types of zoning actions. Just put the list up on the screen here because we're going to be talking about them in more detail. So I'll switch over to the next slide here. And just wanted to show everyone a zoning map. A lot of you have probably seen this before, but you know, every jurisdiction is going to have, and now these days, obviously they're typically online, you know, something that looks like this. And basically wherever you can see the lettering and the numbering, that corresponds to a zone that you can then look up in the county zoning ordinance and understand what uses are allowed and not allowed, and development standards. And when I say development standards, I mean things like, you know, height, allowable density, setbacks, green area, open space correspond to the numbers and letters on the screen. And I'm just going to put up a sample of a Prince George's County zoning map as well. Different county next door, but fairly similar images, different letters, no numbers here. So that's just what zoning maps look like. And like I said, every jurisdiction is going to have something that looks fairly similar to this. And as I mentioned, once you know your zone, you can also look up and see in the zoning ordinance what uses are permitted and not permitted, or perhaps just allowed as a limited use or a conditional or special exception use where you have to show certain findings are made to permit it. And again, every jurisdiction is going to be different, but here, for example, is a list of different types of zoning categories across the top, and this is just an excerpt. The use table is much longer than this, and then you can see down across the side here various uses, and then you not triangulate, but in any case you drill down and you can see, you know, is it permitted? If it's blank, it's not permitted. And again, all jurisdictions are going to have something that looks somewhat similar to this. And then aside from the use table, I kept mentioning development standards. So once you know your zone, this, for example, is R10 zone in Montgomery County, you can then pull up the development standards table and understand, okay, what's the minimum site area that I need in order to develop a detached house or an apartment building, the minimum open space, coverage, lot area, other things like setbacks, building height, density, green area. So there's a lot of things you would learn from the development standard table as well. So those are very important. And another thing to keep in mind, because I haven't given you enough things to keep in mind when you're looking at properties and trying to figure out what you can and can't do, is something called overlay zones. And again, the zoning maps, this is Montgomery County zoning map excerpt, will show an overlay zone. It is very important to see if there are overlay zones in effect, rather than just assuming a base zone applies. Sometimes overlay zones, to be more confusing, aren't always shown on a zoning map. Sometimes you actually have to pull the master plan, as we were saying, the planning document, to see if various overlay zone types have been imposed. It's important to check, similar to what I said earlier in the presentation of where I was got pulled into a project and someone had analyzed the permitted uses and development standards based on a property being located in a county rather than a municipality that had its own land use and zoning authority. I've also been pulled into matters where somebody analyzed a property based on the base zone, and I said, well, it's in an overlay zone and totally different regulations apply. So another important thing to keep in mind as you're doing your due diligence or helping someone do so. So now just talking a little bit more specifically about, again, these zoning actions. So something called a special exception, it may be called a conditional use. Occasionally it's called a use variance. These all relate to the permissibility of a use in a zone. And basically this is where, you know, it's potentially a permitted use, but you have to show that certain findings can be made and certain things can be mitigated, like compatibility and that sort of thing, making sure that there's no stress on adequate public facilities in order to actually permit the use. So it's sort of, you may be allowed to do the use, but you have to show some more as to why it's suitable. And oftentimes the types of things you'll see that might be conditional use or special exception. And again, this is just a broad list and you'd have to look at every jurisdiction and zoning ordinance, but things like hospitals, larger assisted living or senior facilities, home occupations, like you have a home-based business, but not necessarily just that you're an accountant working for yourself, or I'm a lawyer working at home, but where you have folks coming in to work out of your home, larger daycare centers, golf courses frequently, and also most commercial uses in residential zones, because obviously you would want additional scrutiny if you're going to have commercial uses coming into a residential area. And these are the types of findings that often need to be made for approval of a special exception or a conditional use. And again, obviously it's jurisdiction specific, but you can see that essentially rather than just permitting the use by right, there are these various other factors that they look at, and suitably so, to make sure that if we're going to allow this use, which could have a significant impact, we want to make sure it will not adversely affect the character of the neighborhood, and that it is compatible, and that there's adequate public facilities. And then here, the second bullet point is where I said that sort of the planning becomes a little bit more binding. And so here, that basically there is substantial conformance with any recommendations in the plan related to either the property or the area of the property. And, you know, so for example, if the plan says, and I've seen language like this, you know, on such and such road, we don't think there should be any more special exceptions, and you're located on such and such road and want to seek a special exception, you're probably going to have a hard time, because again, this is language I've seen saying, you know, we don't, there's been a proliferation of special exceptions and we don't want any more in that area. So this is where that planning function becomes a little bit more binding. And so much as special exceptions, conditional use variance is related to permissibility of a use in a zone. A variance typically is related to the development standards. So not the use, but rather, you know, the height or the setback or the green area or that sort of thing. So sort of those development standard bulk regulations. And again, examples I just sort of rattled off. This legal standard is, again, you have to look at your individual jurisdiction, but typically the types of findings that need to be made by, for example, a board of appeals for approval of a variance. And I just want to say, and it depends on the jurisdiction, but for example, where I practice, you know, these jurisdictions they're pretty sophisticated. They have, you know, professional planners who advise them. Variances are very, very difficult to get where you have a jurisdiction who strictly applies the findings to it. And so, for example, you know, saying, well, my house is in a single family home zone and it only allows 30 feet in height, but I really want a 40-foot in height house because, you know, it'll look better and it'll give me a better view over the treetops and whatever, you know, that's not a justification for a variance. And further, economic difficulty is not a justification. So saying, well, you know, again, similarly, you know, the zone only allows 30 feet in height, but I had to pay so much for this property that I really should be allowed to build higher to sort of, you know, get my value out of what I had to pay. Economic difficulty is not a justification. So you can start to see that, you know, if the findings are strictly applied, you know, it's tough to get a variance. I do very, very few of them for that reason. So anyway, good to know, but you may not encounter too many of them. And then rezoning, which obviously is something we have all heard of. There's a few different types of ways to have rezoning of a property. Frankly, the easiest is when a jurisdiction undertakes a planning process. So a general plan, a master plan, or a sector plan. What typically happens is that's the planning process. What do we want to see for this area over the next 10, 15, 20 years? And then following that, what they often do is then they do a rezoning of the area to basically conform with what the plan envisions for the future of the area. And in that instance, the jurisdiction is already taking up the plan, already taking up rezoning. You want to participate in it if you want a rezoning of your property, you know, for better or for worse, more density, less density, whatever. But they're doing it anyway. So you would want to weigh in, or you'd want to have your clients weigh in as part of that process, because it's going to get rezoned. So you might as well help craft it to what you would like with your property and what you think is right on your property. And it's some cost because you have to participate, but you're not the one undertaking the application. Whereas for these two that are on the screen, change or mistake rule, you're undertaking that and you're filing an application and paying to try to have a rezoning occur. And this is a tough one because change or mistake is that there's either been a substantial change in the neighborhood since the previous zoning, which given that jurisdictions undertake planning efforts on a pretty regular basis. So like Montgomery County tries to redo the planning and zoning in all areas every 10 to 15 years. It's not always that. But change doesn't happen that quickly. So given that they're on a regular planning and zoning schedule, it's a tough argument. Or that a mistake was made by the county or jurisdiction when it applied the existing zoning. And again, that's tough too. These are very sophisticated jurisdictions that have, professional planners who advise them and assist them. So to say that they made a mistake when these planning efforts are frequently 2 to 3 years long, that's a tough argument too. So I don't know that I've ever worked on a change or mistake rezoning. A bit more common is floating zones. So we talked about the zoning map has zoning classifications for every property, but there's also usually floating zones available. So they float, they hang around up here. In order for a property to be rezoned to them, you then have to talk about how the property is suitable. It satisfies the purpose clause of the zone. Compatible, it would be compatible if this property was rezoned to X, Y, or Z. Character of the neighborhood, that it suits the character of the neighborhood. So a floating zone, again, you can sort of file an application that says, hey, this property is base zone this, but we think it would be suitable for this floating zone for the following reasons. Again, it's a time and cost burden, certainly, but definitely an easier case to make than change or mistake. And then, as I mentioned, practice tip, try to avoid piecemeal change or mistake or floating zones where you carry the burden, because it's much easier to participate in the jurisdiction's regular, every 10 to 15 years planning and zoning process. And then subdivision, and I know we've all heard of subdivision. We probably think of, a lot of us, I'm sure, grew up on, where there was a big tract of land in the past and a developer came in and subdivided and built a bunch of single family homes. So that's sort of the typical notion of subdivision. The interesting thing is that, subdivisions can be re-subdivided. So you can take those small, lots and make them smaller, or what I frequently deal with, because I work on a lot of sort of downtown area projects, is where you've got maybe a whole bunch of smaller commercial properties, and for better or for worse, the developer wants to buy those smaller commercial properties and combine them to build an office building, a multifamily residential building. That's also subdivision. It's just in the other direction. So you're taking a whole bunch of little lots and then making them into consolidated one lot. And the reason for that is, in general, you typically can't build a building across lot lines. So if you want to build a big office building on 10 smaller commercial lots, you have to go through a re-subdivision process to combine them into one new lot. And just a practice tip, I have seen this a lot just in the past year. I don't even think I had this practice tip in my slide from last year, where folks purchased or about to purchase lots that were improperly subdivided in the past by predecessors. And it's really a sticky wicket because typically it's not easy. So say you purchase one of 10 lots that was re-subdivided improperly in the past. It's very difficult for you to just cure that for your own lot. Typically, jurisdictions want you to actually get everyone who's involved in the improper subdivision to fix it together. And as you can imagine, that's very difficult, expensive, can't always reach the people. They're not always cooperative. So definitely, if you're looking to purchase a property or you're representing someone who's looking to purchase a property, make sure you're checking for that proper subdivision, because you might not be able to fix it, but at least you'll know about it ahead of time. And then getting fairly close to the end here, just want to talk a little bit about standard method versus optional method. And again, the terms of art are going to change by the jurisdiction that you're in. But I think similar concepts in a lot of jurisdictions, where sometimes a zone will have two different methods of development, and something called like standard method, or maybe by right, you can achieve a lower density or a lower height, maybe just by going straight to permitting, which is not a discretionary or public hearing review process. But that if you wanted to achieve a higher density and height that is permitted in the zone, but you have to jump through some more hurdles to do so, you may not be able to just go straight to pursuing building permits. You might have to go through what's called discretionary review, where planners with the jurisdiction analyze your application to see if various findings are satisfied. It would go to public hearing before a planning board or a planning commission, or maybe a board of appeals, are the names you might hear. And again, this is where that notion of the plan, the master plan or the general plan, being more binding, because typically if you are asking for a higher density and height, again, the notion that this is discretionary review. And so they would look to see, does your proposed development substantially conform with any applicable master or sector or functional master plans? And this is just various findings that you might see that have to be made for approval of something like a discretionary approval. And you'll see different types of sort of names for discretionary approvals, but things like concept plans or sketch plans or project plans or site plans. Again, any discretionary we usually refer to as anything that isn't straight to permitting. You know, it's not by right. You have to go through these extra hurdles. Findings have to be made. And then a little bit, and I think this might be my last slide, a little bit on judicial review. I am not a litigator. I no desire to be so. So in the knock on wood, a few instances where I've had cases that were appealed to the courts following, as we said, that discretionary review. I refer them out, and I haven't had too many cases that have been appealed. And I hope that it's because I try not to get there in the first place. So, you know, I try to counsel my clients that, you know, just a neighborly and conciliatory and open and transparent discussion with communities is really the best for everyone. You won't always agree on everything, but you really need to try to have that openness and that transparency and discussion. So, you know, make sure you educate yourself on local terminology, you know, what's happening in the area in terms of land use and zoning, what are the pressing concerns that people have. Make sure you're pronouncing the jurisdiction's name correctly when you're meeting with the community. That's something important. It shows respect. And outreach early and often. So, you know, I also always say that, you know, sometimes folks may not necessarily be opposed to the project, but if they are surprised by it, so if they like learn about it from someone else and they didn't hear about it from you directly, especially if they're like an immediate neighbor, you know, they may be very upset just because they were surprised, and nobody likes that. In the same vein, more information is better than less. You know, a lot of these development projects, everything gets filed publicly. And so there's no reason not to share it and let neighbors know how they can easily view the proposed materials. You know, again, just that transparency and communication is very important, especially, I think, I've always felt this way, but I mean, especially in this day and age, you know, when you're looking to develop a property, you're a neighbor just like everyone else. And so you're coming in and having a conversation. You're not necessarily coming in and saying, you know, this is what we're doing. It's, you know, this is what we're planning, want to talk with you about it. You know, I think it's important. You're not always going to agree, but going about it through the right way is really important. And then I do try to talk with my clients, you know, that sometimes you should look to compromise, you know. So if you know, the neighbors, just for an example, the neighbors really want a particular type of, you know, street tree, so placed along the frontage of the property because they love those trees and you can live with it. Why not do it? You know, it's not about winning. I think it's about everyone just sort of getting through the process and, you know, in a way that folks can feel good about, even if you don't always agree on everything. And then just a funny point here, and, you know, I certainly have always felt this way, but it's only been in more recent years in my career that I have more say over it. But, you know, definitely meet with neighbors in the community. You know, don't show up in a black suit, in a dark suit with a big briefcase. You know, again, it's about coming in and talking. You're part of the community. You're one with the community. You're all the same. You're not better just because you're a developer, you know, represented by an attorney. So that's definitely the approach that I try to take. And I fortunately have a lot of clients who I think have a similar mindset, which is helpful to me. So I think that's my last slide. Oh yeah, and then this is just talking about what private law firms and land use lawyers tend to do. The first four are sort of boring and rote, but I think this sort of fifth one here, especially going back to my first slide of, you know, developers and people who encounter land use and zoning are not necessarily commercial developers, you know, like the baker, he's a baker, but he needs land use and zoning law. And, you know, he's probably not going to spend his day shepherding discretionary approvals through a jurisdiction. So, you know, much as you're a lawyer, you're also sort of hurting the civil engineer and the architect and the landscape architect and the traffic planner, because, you know, these folks have things to bake or, you know, cemeteries to run or, you know, churches to hold. So, so I find I'm like a quarterback or a project manager than a lawyer, and actually that's fine with me. So that is my last slide, and so I'll turn it over to Mason and look forward to speaking with everyone as part of the Q&A. Thank you so much.
Okay, great. I will try and take control. Okay. There we go. Okay, well, good afternoon. I'm Mason Imnett. I am with Constellation Energy. So I'm an energy lawyer by training. For me, it's interesting to see how energy issues and environmental issues are coming together, at least in my area of focus of decarbonization or climate policy. And so I'll spend my time talking about energy regulation, but from the perspective of how, if we are moving forward in decarbonizing our economy, how that's impacting the electric sector, how we can go about getting it done, and in the end, ends up being a conversation about coordination and hopefully overcoming conflicts between regulatory structures. So a little bit about me. I graduated law school, ended up at a law firm doing energy law, had no background in the area, but ended up in a practice of former government attorneys that were doing energy regulatory law, specifically of electricity market regulation, and really liked it. It's a mix of economics, policy, engineering, and it's a fun thing to kind of sink your teeth into. I get the fact that when I walk over to a wall and flip a switch that I want the electricity, I want the lights to come on, I want it to be reliable, I want it to be affordable, I want it to be clean. And so that's what really our mission at Constellation is all about. So when you think about decarbonizing so kind of linking between the stuff that Heather was talking about of land use, siting issues you're dealing with in the area of clean energy projects, like if you make the translation, you've got these existing land regulations and requirements that need to be managed, and that's the mechanics of getting something like a wind or solar project online. Well, there's another aspect of the wind or solar project's life cycle of moving into markets, or kind of navigating the regulation of providing service. Who would the entity be selling electricity to, for what purposes, how would it be compensated? And so that takes us to the kind of regulation of the electric sector. And as you step back and kind of think about decarbonization generally, pretty much every major pathway study that has been done has concluded that decarbonizing the electric generation sector is key, is kind of the linchpin of decarbonizing the rest of our economy. So that's because itself, the electric generation sector is a significant contributor to emissions, and so you need to clean that up. But then as you move uses of other fossil fuels and electrify them in order to decarbonize, you don't want to be essentially backfilling or swapping out one use of fossil fuel with another. Also, as we look to move to alternative uses of fuels like clean hydrogen, then again, the electricity used to produce those alternative fuels is going to itself need to be clean. And so there's a lot of focus within the electric industry on decarbonizing as quickly as we can to be able to support the transition of the rest of the economy. Now, when you think about who is really pushing the policies in this area, it's the states. The states are the drivers of GHG reductions within the electric sector. We have at the federal level tax policies, we have an R&D focus with funding, but we don't yet have any federal statement of mandatory policy or clean energy requirements or decarbonization requirements in the energy sector at the federal level. And so the states are stepping in and filling the gap. We've got about half of the states now that have some form of either direct, 100% clean, 100% renewable requirement, or a very deep decarbonization requirement, which again takes you back to you can't deeply decarbonize all sectors without first getting to the point where all or nearly all of the electricity being generated is itself clean. We've also got corporate buyers that are taking action. There are about 75% of Fortune 100 companies have some form of clean energy or climate commitment. And so that is a very important actor to keep in mind here. I'm going to focus really more on the utility and the electric generation sector, but definitely keep an eye on the corporate buyers to the extent you become active in this space. So as we think about the challenge before us of decarbonizing the electric sector, and as I said before, it's the linchpin. We've got the technologies to do it. We have the existing carbon-free resources. We've got existing nuclear. We've got wind, solar, geothermal, hydro. We have advanced technologies coming online, perhaps advanced nuclear. And we have the existing policies in place to be able to do it. We have clean energy standards, RPS standards, tax credits. But as you look out in the future, the amount of investment needed in this area is really just staggering. You can see at the top, this is just taking some studies in New England, looking out if we were to meet 2050 goals, the amount of clean energy generation that we're going to need on the right-hand side of this chart at the top compared to the historical development, which is kind of from the middle to the left. You just see kind of the staggering amount of investment that we need in the area. And along the bottom, you see, as we look out into the future, what market operations will look like, what the revenues coming out of electricity markets would look like for these resources, to answer the question or begin to answer the question, well, how do you make this happen? How do you do it within the existing regulatory structures and the market structures? Bottom left is a projection of, at the left side of that chart is kind of current amount in the blue of how much money comes out of market operations compared to the top greenish color, how much comes out of state support or clean energy program support, basically. And as you look out over time, you see the policy support growing and the market revenues declining. That's because the way that these markets are structured, they pay based on marginal cost. And so the marginal cost, the next increment of production coming from a renewable resource is very low because you build the plant, you turn it on, it takes the sun and the wind, it produces electricity, and then results in a market price that is relatively low. There's a big upfront investment, but there's not ongoing a significant amount of ongoing operational costs, which then brings that market price down, that brings the revenues down, which then brings up the amount of state support that you need. And so on the right side, it's just another graph showing the market revenue reduction over time. But the takeaway here is, as we look into the future, it becomes more important for policy support for clean resources going forward, because the nature of their interaction in the electricity markets means they're getting less of their money from the markets, they're getting more money from the policy support programs. So then as you think, okay, well, that's just factually, table setting as we look out into the future, clean resources coming online, they're going to need that support. Who are they going to get the support from? So the electric industry is highly fractured across the country. This is a map of Edison Institute companies. Edison Institute are investor-owned utility companies across the United States. And so about 100 or so. That does not include municipal entities and cooperative entities. So other utilities that are publicly owned, about 1,000 of those. Those tend to be very, much smaller and operate throughout the country. And so you layer, these are the entities that are providing electricity to us. They're the service providers. So hundreds of private actors and about 1,000 public actors in this space that are complying with requirements or adopting their own clean energy target goals, their own decarbonization goals, and acting individually, sometimes in coordination with each other, but each trying to meet their own goals. And within a range of jurisdictional structures as well. So in the kind of northeastern part of the United States, they have what's referred to as retail competition. The companies that own the wires and deliver the electricity are different than the companies that own the generation, and the generators compete against each other in the kind of level platform of the utility wires operator, which delivers that electricity. You compare that to other regions like the Southeast and the middle part of the West, Those are what's referred to as vertically integrated regions, where the utilities own the generation, they own the wires to deliver, and there are some what's referred to as merchant generators, competitive generators operating within that jurisdiction, competing against the host utility, but it's a different regulatory structure. And the policies that you would adopt for one set of operators, so say the fully competitive northeastern markets, aren't necessarily going to work in, say, the southeast, where you have the dominant host utility providing most of the operations, and a handful of merchant generators attempting to compete against it. So, takeaway here is it's a highly fractured market setting in which the highly fractured operators of the assets are participating. So although the kind of individual actors are fractured, and the kind of local markets that they're operating in are very specific, there are what are referred to as regional markets, independent system operators, or regional transmission operators, ISOs or RTOs. If anybody starts to become active in the electric regulation space, you will hear people talking about ISOs and RTOs. So these are federally regulated, tend to be multi-state entities which operate high voltage transmission lines and an associated wholesale electricity market. So all of those prior kind of direct utility providers of service would operate within one of these markets to essentially buy electricity on an exchange or auction-based mechanisms in order to then deliver that power to their customers. Since these are interstate in nature, they are subject to FERC jurisdiction. The Federal Energy Regulatory Commission has exclusive jurisdiction over these entities, as compared to the kind of local operation of utilities, which are subject to state jurisdiction. So you see within these regional entities, a collection of states. So say that PJM region, Pennsylvania, New Jersey, Maryland collection, which has extended over time to incorporate additional states. That's a collection of, and that's the main region in which my company operates. It's a 13 jurisdiction region where not all of those jurisdictions agree with each other. West Virginia does not have similar policies as Maryland and Delaware, and Virginia and Kentucky feel about things differently than Illinois. And so there's an added layer of complication of the underlying policies and goals of an individual state, where you're in this framework of, we don't have federal clean energy policy. Each state is deciding on its own what policies it would like to pursue. It's regulating its utilities operating in that state, but then those utilities are operating in a regional market that is regulated by FERC under the Federal Power Act. And the Federal Power Act jurisdictional standards are that service needs to be provided at just and reasonable rates that are not unduly discriminatory. It's from a 1930s era statute. And that term, just and reasonable, not unduly discriminatory, those are pretty flexible. They can be interpreted to mean just about anything, but with 100 years of precedent, the agency has interpreted those requirements to mean that these regional markets generally are fuel neutral in nature. They do not discriminate between different types of customers and different types of generators operating within their footprint. So if you can imagine a state like New Jersey, which has very expansive clean energy requirements, goals, a number of state programs supporting clean energy, the retention and the expansion of clean energy projects operating within the PJM market, where the PJM says, I cannot discriminate among different fuel types. And West Virginia saying, well, we're really worried about our coal, and we're going to want to make sure that whatever happens in this regional market doesn't impact the operation of the coal resources. That's the kind of dynamic that companies are operating in as we're trying to achieve these decarbonization goals. So there's a lot of words here. Hopefully the slides will be provided to folks, and anybody that wants to look at this a little bit further can certainly do so. Takeaway here is just that there is a recent example of this friction between the federally regulated market and the policies of states in particular that are supporting clean resources. where there have been about half a decade of litigation going back and forth, where states supporting clean energy resources, those carbon-free generators, the wind, solar, the nuclear operating in the regional market, are able to offer at lower prices because of the support that they're getting from the state. And that's kind of represented by the left graphic up at the left, the green being the state revenue, and the blue being the residual amount of revenue that they would need from bidding into these regional markets. Well, the resources not receiving the state support, which are primarily the fossil resources, came in and complained to the federal regulator, FERC, and said, well, that's not fair. They're out competing us and you should do something about it. And so FERC did in kind of the 2016, 2018 era, and granted a complaint, required the market operators, the regional market operators, to institute what's called the minimum offer price rule, or MOPR. And that reprices the bids of the state supported resources to say, well, you're getting some state revenue, you need to just put that aside, act like it's not there. That's not fair. Other resources are not getting that. And you bid into the regional markets as if it's not there. And you see on the bottom right, well, what happens is that ends up pricing resources out of the market. So the fossil resources are selected instead. The state continues to make payments to the clean energy resources. Those continue to operate. They're needed for the state requirements, but they are not selected in the regional market, which instead over-procures resources because it's ignoring the state resources. And so this is the type of friction that you see when you've got federal policies which are designed for one purpose, and they are running up against state policies which are designed for another purpose. And they're not aligned in order to achieve, our longer term decarbonization goals. And it's because people don't, within the policymakers, that they don't share the same goals. The federal regulators at the time at FERC were under the Trump administration, and there was no federal decarbonization requirement for them to comply with, and so they were not going to do that and take actions, in fact, directly against the state clean energy programs. We saw that flip with the change of administration at FERC. The existing Democratic commissioner became chair, with a change in composition as commissioners rolled off. FERC is a 5-commission regulatory body, and the sitting president gets to designate the chairman, who then sets the general policy of the agency, but subject to the majority vote of the sitting commissioners for any proceeding or docket or decision within the agency. And so that's an additional layer of complication that, from a policy perspective, the leadership of the agency may be changing over time, but they still got to get the votes of their sitting commissioners in order to get something in some particular decision done or some particular change in policy done. And those commissioners are from different parties, and they serve on 5-year staggering terms. And so you've got to kind of manage this constantly shifting political and regulatory dynamic, which is, that's normal, I guess, in a sense, for regulatory commissions like this. And so folks that are active in the administrative law area, that's not going to seem unusual to them. But it is for folks that don't practice in areas like that, just an additional layer of complication to be aware about. So just a footnote on this, that the MOPR litigation, it's still ongoing. There have been, under the Biden administration, with the change in chairmanship, a change in the underlying policy. It's this restriction has largely been removed within the regional markets, but that's subject to appeal, and the case is currently pending before the DC Circuit. And so the discussion is by no far done. The current impact of this rule is pretty limited because of the actions that the agency has taken under new leadership. But we'll see. It could revive could pop back up at any time. So as we think about going forward, what are ways that we can evolve the existing regulatory structures, the legal paradigms governing our electricity markets to support the clean energy transition. One obvious one is the implementation of carbon pricing. So you'd put a price on carbon, and that would become a cost of operation. Within the electricity markets, you would just rationally, the markets would choose among resources that are most efficient, taking into account the carbon externality, and you'd really kind of minimize the need for the state programs, because the additional revenues associated with not polluting the carbon externality would be flowing through the market mechanism. So that, from an economist perspective, is by far the most efficient approach to take to support decarbonization. But from a political and regulatory perspective, it's a very, very difficult thing to achieve. Implementing any sort of tax or adder on costs is challenging. There are states that have implemented. On the top left, you see what's referred to as the RGGI states, the Regional Greenhouse Gas Initiative. That is working its way through the Mid-Atlantic up to New England, a number of states who have implemented a carbon pricing proposal. But again, because of the way these regional markets operate, the carbon price within the market can only go up so high before it starts to adversely affect these jurisdictions in relationship to the other states in which they are competing within the same regional market. So there's kind of a natural ceiling on the level of the carbon price in the programs. There are ways to deal with that, what's called border adjustments, leakage mitigation, but so far, though, we have not been able to see that develop, just again because of the political realities. Also, top right, you see that California and Quebec are in a carbon pricing program, just demonstrating you don't need to be right next to each other to implement a carbon pricing regime. You can do it, effectively virtually. Ontario used to be in that program, but pulled out. So moving from carbon pricing, which is not really politically realistic at this point, the way that states are making progress on the clean energy expansion is through either direct state procurements or, in a minute, I'll talk about regional coordination. So typically you'll see states undertaking procurement proceedings or mandates for the utilities within their jurisdiction. On the right is a order from California. On the left, a multi-state order from Connecticut, Massachusetts, and Rhode Island. So you can have states directing the entities providing service within their jurisdiction that X amount of their deliveries need to be provided from Y type of resources. You can get specific like that. You can set emissions targets and then let the utilities compete for whatever combination of resources would meet that emissions target. But the general structure is that the states are calling the shots. They're deciding what resources they want operating within their jurisdictions, and they're directing their utilities to go out and accomplish that. An alternative mechanism is, again, kind of going to the regional framework to use some efficiencies of having competition among broader regional footprints and take those clean energy mandates and move them into a regional market mechanism. There are existing mechanisms. This is on the bottom right, that PJM region that I mentioned earlier, the top left, or the bottom left, the New England region, and then New York State. Each one of these has an ISO or an RTO, one of those regional market mechanisms. And these regions do already have existing auctions which look out into the future, procure resources, or make commitments for periods of time for resources to be available in order to be called upon when they're needed. And so you could take the clean energy goals of any individual jurisdiction and kind of fold that into that auction mechanism. Sounds good. The difficulty is then that becomes subject to FERC regulation. And as I was talking about before, changes in administration and changes in and the dynamics of the FERC commissioner makeup mean that the achievement of a state policy is handed over to regulators that the state obviously don't control, right? They're ceding jurisdiction to the federal regulator. And that's deeply uncomfortable to the states who have their own obligations that they need to meet their their statutory or administrative, or however their clean energy requirement was established, they need to meet those. And if the federal regulators make a decision that's adverse to the state achieving its goal, then the state just really has very little remedy if it's already ceded that jurisdiction. And you can see that play out in each of the regional dynamics within New England. The states are generally aligned on the clean energy policies across the jurisdiction. And so they are much more willing to talk about the possibility of regional coordination in their ongoing stakeholder proceedings right now on ways the states can coordinate within that ISO New England footprint. Within PJM, there's some general conversation, but really gets shut down pretty quickly by states like Ohio and West Virginia, telling states like Maryland and New Jersey, well, we don't have much in common. And so if we can set up some sort of program that you achieve your goals and it doesn't get in the way of our asset operation within this regionally interconnected market, we're fine talking about that. But that's a pretty challenging a tall task to be able to achieve. So that takes us to, where do we go from here? There's really no single path forward. We have, under the Biden administration, a very clear statement of where we hope to be in 2050 with 100% clean energy economy, but no statement of federal policy, no mandate. And so the states that, do have a bit of tug of war. The states themselves do not agree on where we should be going. And in the absence of any sort of federal mandate, it becomes difficult to see how we achieve the goal of 100% clean energy, even though, as I started out, it's something that my company deeply believes in. We are already 90% carbon free in our output. We want to get there for the remaining 10% for our company and get to 100% for all service providers in the electricity industry. But it's very much an open question within the existing legal and regulatory structures of how we're going to do that. So with that, I will turn off, and I think we can go to Q&A.
Excellent. Well, thank you both so much for these fantastic presentations. I really appreciate it and found them very informative. So we have a few questions right now, and definitely want to remind folks to please enter any questions you have into the Q&A box. This first one, I think, is a good one to start with. It really intersects both issues. And so I'll throw this out to either of you that would like to answer it. The questioner has a specific question about variances designations. They included a link to BLM's solar zoning maps. And they note that this map shows a pretty large area designated as a variance zone. And they were curious as to what this actually means, especially whether this means the government can still develop those areas with solar energy.
Maybe I'll just, and I don't know, Mason, if you know more specifically about this, but I was actually, and obviously you just finished talking, but I was looking at the link while I was off camera, and it looks like that is specific, at least from what I can tell, that is very specific to a BLM solar program. And so that is just my gut from looking really quickly, just because it's not something that I'm specifically familiar with. But this may well be an area where you sort of have the federal government stepping in, at least on a federal government program that sort of preempts or trumps local, at least if you're trying to do like the BLM solar program. But I don't know, Mason, if you know more, since it relates somewhat to energy, if you know more specifically than me.
Yeah, I don't know specifically on this, but I agree with you that generally from say the solar developer perspective, right? They have local, state, federal, private, a whole host of requirements and issues that they've got to work through. And so that is my assumption is, here as well. If you're on BLM land, you're going to be dealing with BLM issues, but those are not going to be the only issues you're dealing with.
Right, that was my gut too, yeah.
Excellent. This question is for you, Heather. This question asks, could you talk a little bit about how your work intersects with coastal laws and policies, specifically to preserve coastal wetlands or wildlife or prevent coastal runoff?
Yeah, absolutely. So, the two jurisdictions I mentioned that I practice in, Montgomery and Prince George's, themselves are not on coast per se. Of course, we have lots of rivers and streams and whatnot. But I guess just sort of two things. So we're not far from coast, which is, Annapolis and the Bay and whatnot. I don't practice there. But one thing I didn't talk about is that areas, for example, adjacent to the Chesapeake Bay are governed by critical area laws where based on, and there's various designations in terms of how close you are to the coast and to the bay. But basically, I think there's 3 different classifications, and depending on which classification of critical area you're in, there's additional restrictions that layer on top. So sort of it serves in some ways like an overlay zone, like I was talking about. So that's, for example, out towards Annapolis area, they deal with that. We don't have any critical area here, again, just because we're not adjacent to the coast. But because you are also asking about runoff, I did want to just talk quickly about stormwater management, which is such a fundamental part of development. And frankly, I don't analyze stormwater, but our civil engineers look at stormwater, frankly, as one of the very first things that when you're looking at any site, before you can even really file for permits or any discretionary approvals, you already have to have essentially analyzed your stormwater and how you're going to handle your stormwater and runoff. And at least in Maryland, and I think probably generally, the trend is towards runoff being handled on your site. So essentially there is no runoff, right? So it has to be controlled on your site from typically both a quantity and a quality perspective. And so even the notion back, of a decade or two ago, where maybe you've got all the stormwater from an area running into like a pond or a sump or something like that. Now, really what the laws favor is things like micro bioretention facilities, where it runs into an area, planted with native plants and various sort of soil matter that actually filters and drains the water, but keeps the, the chemicals out of the system. So anyway, just wanted to answer that in sort of 2 parts, because stormwater is it's so fundamental that I think we almost gloss over it, because oftentimes stormwater has been analyzed well before I even get involved in a project, just because it's so critical.
Perfect. Thank you so much. Mason, this question's for you. Question says, you mentioned the frictions between state policies and FERC regulation in the MOPR context. Is there any chance that courts would more broadly invalidate state renewable policies, or perhaps find them preempted because of the impacts they have on federally regulated interstate wholesale markets?
Yes, there are a line of cases involving states supporting particular resources and stepping over the line of FERC's exclusive jurisdiction over the price to be paid for the sale of electricity at wholesale. So that was a mouthful. FERC's jurisdiction within the electric sector applies to wholesale sales. So think, generator sells power to somebody who is then going to use it to provide service to somebody else. That's different than the direct delivery of electricity for use by that, end use consumer. That's a retail transaction that's subject to state jurisdiction. But when you think about, big clean energy projects, they're all, predominantly all operating at wholesale, because they're going to sell to somebody who's going to, eventually link to a customer, and when somebody flips the lights on, they're going to pay for that power. And so there are some instances where states have constructed programs that attempted to determine the price to be paid to the clean energy resource in a way that ultimately set the price to be paid for electricity, and cross the line of setting the electricity price instead of setting the attribute price. So the way most of these programs are set up is that a renewable or a clean energy project, a zero emission project, will generate a credit that is tied to the production of electricity. So you produce 1 unit of electricity, referred to as a megawatt hour. You produce a megawatt hour of electricity, the state gives you 1 credit associated with it, a renewable electricity credit, an energy attribute credit, and emissions-free energy credit. Like, they have different names, but you get the attribute credit in a megawatt hour, and then you can sell that attribute credit to somebody who has a compliance obligation associated with the delivery of clean energy. And that's the way that these programs kind of generate money. They can get very specific. So for example, offshore wind, they have ORECs, offshore renewable energy credits. Those are tailored specifically to offshore wind projects that qualify. Every megawatt hour production from the OREC facility is then sold, and there are specific, say in New Jersey, utilities have obligations to have a certain amount of ORECs tied to their consumption, and that creates the revenue stream to the renewable project. In some instances, states have wanted to say, well, wait a minute, the amount of money that I'm going to give for that credit depends on how much money the resource is getting from market operations. And I don't have an unlimited pocket. And so if a resource is otherwise realizing enough revenues from the electricity market from the sale of power, well, then I'm not going to give them extra money because they don't need that. They're covering the cost and risks of their operation from their market revenues. And so these programs have become more sophisticated over time. But in the early days, some of them were written in a way that created a contract for differences to say, well, I'll commit from the state perspective, I'll commit to give you, $50, but I'm going to tie that $50 to the price of electricity. And courts have found that effectively set the price of electricity. States can't do that. And those programs have been struck down. Though the case in which that came up actually didn't have anything to do with a clean energy project. It was more of a local development project or local development benefits associated with a gas-fired generator. In Delaware, there was another case involving Maryland, again, a gas-fired generator, but the same logic applies to the extent that the state is attempting to determine the price of power through the programs that are subject to the state's jurisdiction. That crosses the line. And so we and other clean energy operators are very conscious of what states can do within their authority and not, and do our best to advise folks that are wanting to set up policies to not cross that line.
Excellent. We had a really interesting two-part question just come into the chat, and I think I'm going to split the questions up, but they're for both of you if you both have things to add to them. The first part of this question is from the local government perspective. Have either of you seen model ordinances or zoning tools for regulating solar farms?
I guess maybe I'll just weigh in quick. So I would say, yes, this has been a big issue, certainly in Montgomery, Prince George's as well, but very recently in Montgomery County. And they actually were trying to, and this is probably just in the past year or two, and I'm just giving this as an example, but the short answer is yes. I think increasingly this is becoming something that folks are looking at, and for the most part trying to encourage, right, which is a great thing. But then there were also people who are pushing back on it. And in Montgomery County, the upper, I think it's 1/3 of the county is what's located in what's called the Ag Reserve, Agricultural Reserve, which is supposed to be a relatively undeveloped rural agricultural farming type area. But the county was actually pushing to allow more solar there, and actually allow more solar that would still allow for agriculture and animals and whatnot underneath the panels essentially. And it would have been a broad expansion, and it got a ton of pushback from some folks because they didn't want to see the expansion of the solar, and they thought it would ruin sort of the character of the community. And it ended up sort of being so neutered, the proposal, for lack of a better word, that the original county council member sponsor ended up voting against his own bill because it had just been stripped apart and such a shadow of its former self. So, stay tuned on what actually happens on that. But again, the short answer is that on the solar, absolutely, I think people are increasingly looking at it. And, certainly now with gas prices as high as they are, I think it's going to be something people are looking at even more.
And I don't have anything to add specifically to solar. I will say, those resources then need to connect to something. They need to connect to the grid. And there are all sorts of complicated rules and regulations on how that is done. And there are, and most of those rules were written for kind of legacy generators, fossil generators. And there has been a lot of work, going back, probably about 10 years from, again, this is subject to FERC regulation because it's connecting to the wholesale power grid. A lot of work to update those rules to streamline. But as we are learning more about, say, pairing solar with storage, there's continuing work to go on there. So again, they become model in the sense of one region, sees this kind of electrical engineering issue, tackles it, and then those rules start to work their way into other regions.
Perfect. Thank you both so much. And the second part of this question, it's really a second question, I think it's a really interesting one, hitting on a pretty hot topic issue right now. It asks, have you run into crypto mining in areas without zoning? And perhaps we could talk a little bit of, if we have expertise, talk a little bit about the energy usage aspects of crypto mining as well.
Yeah, when I hear crypto, I go running for the hills, figuratively speaking, in any number of levels. So I will definitely see if Mason has anything to say here.
Yeah, it's interesting. We've had lots of conversations about it. So one of the questions in the chat is like, how do we achieve 90% emissions free? We are largely a nuclear company. We own lots of resources. We own wind, solar. We own a large hydroelectric dam that I'm actually sitting at today, the Conowingo Dam. And we have some fossil. We have no coal. We have a couple of very new gas-fired generators down in the Texas market, as well as one older one that's really kind of the bulk of our operating fossil. We have some older kind of fossil units that don't run very much. They run for reliability. It's really our nuclear fleet. Even though it's only 2/3 of our generation, it produces 90% of our output, 100% emissions free. And there have been lots of questions from crypto developers about potential interest pairing with our nuclear facilities because we're always on, we're super stable, we run 24 hours carbon free, and that's attractive to the crypto community. There are questions about, right, as was kind of hinted at, the emissions implications. And so we are, on the one hand, would be able to use a totally carbon-free resource in order to power crypto mining. But there are local concerns about, is that the appropriate use for the electricity? A significant portion of our fleet is also under state programs. We have already committed to operate for a number of years, typically out until the 2027 time period, committing the operation or committing the production of our clean energy megawatts, creating what are referred to as ZECs, zero emission credits. And so we don't, we've already committed the kind of clean attributes associated with our resources to the state. And so if we were to co-locate with, say, a crypto miner, there's an interesting emissions accounting issue that arises, to the extent we are operating, we provided our emissions, our attribute to the state under a state program, and then you were to co-locate a crypto miner, even though electrically what's happening is that the power is flowing from our plant to the co-located crypto miner. From an accounting perspective, that's brown power coming from the grid because we've already given our emissions-free attribute to the state for compensation through a state clean energy program. So it's quirky. We do have one facility, a crypto mining facility, coming online at one of our two fossil plants down in Texas, and that is a pricing issue for the developer, and it's our kind of toe in the water to see what this thing is about. But we're seeing as we go.
Perfect. Thank you both so much. I think that's a really interesting and certainly hot topic issue right now. This next question is for you, Heather. This question asks, have you seen a trend away from the use-based or Euclidean zoning codes towards form-based zoning codes? And if so, what practical effect do you see that having for property owners?
Yeah, definitely. I don't know that I'd say at least, and again, I obviously really only primarily practice in 2 counties plus the municipalities within them. I don't know that I would say I see it as a trend increasing or decreasing, but I would say that there's a mixture of them. So for example, actually Prince George's County did just adopt a new zoning ordinance. It took effect just about 2.5 months ago, which is largely a form-based code. It still has Euclidean zones and land zones on properties, but it's largely form-based. Montgomery County is not really form-based so much. And I guess I should actually say too, for folks maybe who are not aware of the difference of what a form-based code is. So, it's sort of a code where rather than picking it up and saying, oh, you're allowed to have a maximum density of, I don't know, let's say 16 townhouse units per acre on a property. Rather than sort of setting out that number, what it does is it sort of sets out more, sort of more qualitatively. It basically starts to build, a building envelope over a property. So it sort of says, well, you can't go more than this in height, and you have to have 15% open space. But within that, and it may establish setbacks, but then you can sort of carve it up how you like. And it's more form-based in the sense it's more like images as opposed to like, words and numbers specifically. And I guess the, practical effect for me, at least for me, and I can only speak to that, is, if somebody's looking at a property and it's in an area that's governed by a form-based code, personally speaking, as a lawyer, and I would tend to think for a property owner too, I find it easier to read something that's not a form-based code, because I can say, okay, you can do, 16 townhouse units per acre, or you can do, 100 multifamily apartment units per half acre, or whatever it may be. And I can say, all right, that's that. But where you have a form-based code, what I typically say is, well, I could tell you what it said, you can't go higher than this, and you've got to have 10% open space, and, maybe there's setbacks, but, you're going to have a civil engineer and architect put pen to paper and draw out what the form-based code actually allows, because I can't in words tell you. They're really going to have to sort of paint that visual picture. So to me, it's harder when it's a form-based code, because I can't just give a client hard and fast numbers, and they really actually sort of on the front end have to have someone actually sort of sketch it out. So that's just my thoughts on the topic.
Perfect. Thank you so much. I have a question here. I think, Mason, I'll throw this to you first, but Heather, if you have anything to add, please feel free to do so. This person states, I worked in a facility that had solar panels over the parking lot. Why don't we see more of that?
Yeah, I saw that question. It's interesting because we put solar panels on our house this spring, and to be blunt, comes down to money, right? You got to pay for the things. And within our my personal decision process was there's upfront funding. You have a choice actually between upfront funding or somebody else. Essentially, you finance the project. And as you look out, over the life of this project, it's going to give you electricity savings. There are going to be emissions benefits associated with it, or clean energy benefits associated with it, which takes you to, is there a program, typically at the state level, might be local, that provides compensation for the credits, the clean energy credits that are going to be generated by the project. And then are there any other, forms of compensation or benefit associated with the project? And so for us, there was a federal tax credit associated with it, an investment tax credit. We had within the District of Columbia, where I live, we get revenue associated with the credits, the environmental credits that are generated off the project. And then I get bill savings because I'm producing electricity that's self-consumed. And at times, if I'm generating more electricity than I'm actually using, that's actually going back on the grid, and that creates additional bill credits for me. And so I'm going to look out over time and have some estimate associated with the value of these 3 different benefit streams to me. And the solar development company did this, right? They gave me a report that said, assume this, assume this, assume this, and then look out for a number of years. This upfront investment will pay for itself in 8 years was the number for me. But, the owner of that parking lot, who owns the parking lot, and who what is their revenue source? Is it owned by the company that is, that you're parking at? And this would be, a relatively possible minor investment compared to their total operations. Do they have somebody who would kind of navigate all of these issues? Would they want to, like I mentioned, there's a financing option. There are companies who come in and say, don't worry about it. Let me use your space. I will give you X dollars a month for me using the space, and all these variable revenue streams I will take on. But you are agreeing to give me use of your space for 20 years because that's how long that thing is going to sit there. All of these considerations have different, will feel differently to the particular actor, depending on kind of where they're coming from. And I think that's the practical reality of why we don't see solar PV in more places, is that it takes time and there's a certain amount of risk management that goes with it. I'm an energy geek, and so it was kind of fun for me, and I can plug in my EV at my home when the solar is generating electricity, and it makes me feel good. But not everybody's gonna share that level of enthusiasm for kind of working through some of these complicated issues. So I think it's just a practical reality.
Thank you. Heather, we have a couple questions here for you. First one I'll throw out is, could you talk a little bit about earthquake zones in land use?
Sure. So I candidly know very little about them. Fortunately, here in Maryland, we don't get too many earthquakes, although Mason, sounds like you've been here for a while, so you probably remember the one in, what was that, Southwest Virginia, that all of us mid-Atlantic people froze and ran out of buildings, which is not what you're supposed to do, apparently, and people from California in my building laughed at us. Yeah, so I couldn't say specifically. My gut is that where those are, probably they function as something of an overlay zone, but unfortunately, or fortunately perhaps, I don't have much experience with those here in Maryland, unless or until the tectonics of our world change, and unfortunately maybe we have to face it more here. Sorry about that.
No, that's perfect. And then follow-up question here is, could you speak more of how the Clean Water Act and MS4 permits apply to zoning and planning?
Yes, it was funny. I saw that come in, and so I was doing some Googling here, and I think this is sort of an example from one of my slides early on, where I said that various like in Maryland, the state has certain authority that they pass along to the counties and the municipalities to implement. And so I was actually just looking on Montgomery County's Department of Environmental Protection website, and essentially it looks like the federal government enabled Maryland to sort of enforce and implement the provisions, which then were further enabled to Montgomery County. So that's sort of the long way of saying that in terms of day-to-day practice of land use and zoning law, I never specifically encounter Clean Water Act issues or MS4 issues, but that is because we deal with the local jurisdictions, and the County Department of Environmental Protection has to have, at least as a baseline minimum, regulations and laws that satisfy the state, and then the state obviously has to have laws and regulations that meet the minimum established by the federal. And the lower jurisdictions can be more strict, but they can't be less strict. And actually what we frequently see in Montgomery County, well, Maryland in general, I think, but certainly Montgomery County, which is a pretty liberal and progressive jurisdiction, is that oftentimes their standards are stricter than even the state standard, which the state standard may well be stricter than the federal standard. So again, sort of that was a lot of words, but I wanted to just use it as a means of illustrating that on the day-to-day practice of land use and zoning law, I don't ever do that, because we follow the rules and regulations established by the jurisdictions, which in turn have to comply with the baselines established by those.
Perfect. Thank you so much. Mason, I have a couple for you now as well. The first one I'll ask is, how do these decarbonization efforts at the state level tie into the Paris Agreement and national commitments / contributions? If they're being used for NDCs, how is double counting being avoided?
Yeah, so there are two flavors of clean energy commitments at the state level. One is GHG reduction, and so those will often be tailored to Paris Agreement type commitments, and another is a clean energy commitment. And so we will be 100% clean by 2040, and by 2030 we will be 70% renewable or something like that. And so those won't necessarily have a direct translation to GHG reductions. They are implemented to kind of force particular outcomes to lead to the GHG reductions, which would be in furtherance of the kind of first set of goals. In terms of reductions, and I'm not actually, I don't have personal familiarity with the way that the kind of local or state level commitments around GHG reductions then get incorporated into any sort of accounting or reporting with respect to national level progress towards targets. My gut, not having the personal experience, is they don't. The accounting at the federal administration level is, what are we seeing in outcomes, right? Because under the Biden administration now, there are commitments to achieve GHG reductions over time. And so the administration would take into account its projections of where we are on that pathway. They would fold into that where the states are, where they kind of currently are, and where they have committed to be, and that should take care of any sort of accounting issue or double counting issues. But the kind of factual, what is our level of emissions? That just is what it is, and there wouldn't necessarily be double counting in that, right? Because it's just what is our level of observed emissions. It's as you look out in the future and how you achieve emissions reductions, and that is just going to change with administration over time, given that we don't have consistent federal policy.
Perfect. Thank you so much. One more question for you here, Mason, is, sorry. Pennsylvania just implemented regional greenhouse gas initiatives. There's a lot of effort from political parties in courts to nullify this action. And the questioners generally asking is, how successful are these programs at sustaining court challenges?
Yeah, so this is, in fact, we are involved in this proceeding, and it's fascinating for administrative lawyers. So what's happening in Pennsylvania is, for stepping back, regional greenhouse gas initiative. It is a multi-state carbon pricing program. I had the map up earlier in the presentation. So runs from basically Virginia up into New England. Virginia kind of put a pin in it. They're looking to pull out under the new Youngkin administration. But Pennsylvania, under the Wolf administration, is looking to move into RGGI. The Republican legislature is very much opposed to RGGI participation. Wolf knew this at the beginning of starting the regulatory process to move the state into RGGI, and there have been challenges along the way from the legislature. Laws passed that would preclude the Wolf administration, from using its regulatory authority to move the state into RGGI. Governor Wolf has vetoed that legislation and has not overcome, it hasn't been subject to a veto override within the legislature. That's happened multiple times. So for the past several years, the Wolf administration has gone through this regulatory process to promulgate regulations that will move the state into RGGI. In other words, emitting resources, which tend to be larger fossil fuel power plants, have an obligation to procure allowances associated with the volume of emissions which they are producing. And then those allowances trade on a market, and each of the RGGI states have their own obligations for the generators in their jurisdictions to get allowances, and all the allowances then trade within this multi-state market. And that's kind of mechanically the way the program works. So when the regulations were about to be promulgated, and I think it's called the Pennsylvania Bulletin, their version of the Federal Register, and the legislature filed, first the quirky mechanics. When a regulation is published in Pennsylvania, it's got to go to the what's referred to as the Legislative Reference Bureau. It's kind of like the Federal Register publication entity. That is a legislative body. And so the legislative body sat on the regulation and said, you don't have authority to do this. So there's some back and forth with the administration debating whether it was going to have to take the legislature to court to publish the regulation, which had been duly adopted. The Attorney General got involved. Eventually, the regulation got published, which then triggered the flip side of the Republican leadership filing an injunction against the state, attempting to prohibit the state from moving forward and implementing the regulation, which became effective June 1, right? June 1 or July 1. It either just became effective or it's about to become effective. But the obligation is for the emitting resources to procure an allowance, which would be tendered during a compliance period, which is going to be later in time. So they're going to be subject to, okay, now I'm emitting, I got to get these allowances, but I have a certain number of months before I go and get the allowances and then tender them to the state for compliance. And so we're in this litigation phase where people are arguing about the applicability of this regulation, the enforceability of this regulation, which hasn't actually kicked into enforcement because that compliance obligation comes at a later point in time. So the specific question was what do we think about the success here? The courts in Pennsylvania, as many courts, tend to be political, and the trial court tends to lean Republican. And so there is some expectation that the legislature is probably going to have a better likelihood of success at the trial court. The Wolf administration has already indicated that it would seek an immediate appeal to the Supreme Court, which tends to lean Democrat. And so the kind of general end of the day expectation is that the regulation will survive the legal review process. It's going to take a little while to work its way out. This whole saga, it just demonstrates how complicated administrative law matters are. This whole regulatory proceeding took 3 years. There's probably going to be another year of litigation associated with it, and then multi-years of compliance implementation. And so stepping back, we think about, we need this massive amount of investment in the clean energy space, and companies like mine and others that are coming forward and saying, well, we want to make this investment. These assets are going to run for 20 or 30 years. These are very significant, multi-billion dollar, assets and investments. And we have these regulatory proceedings, which will have very significant shifts in the market and regulatory dynamics, which take 3, 4, 5 years to resolve. And that's the reality of the world that we live in, which is what makes it so difficult to think about how are we going to achieve this level of investment unless we all get aligned on what we're trying to do and kind of streamline this stuff, which takes us back to, rule of law, regulatory process, consistency.
Thank you so much. I've got a few more questions in the chat here. This first one I'll throw out to you, Heather. This person states, I've observed our zoning hearings board render a decision when a requirement included how the applicant is requesting relief from unnecessary hardship. If the property is not zoned for the use and that was known when the applicant required the property, how is that an unnecessary hardship? Can you please comment on how unnecessary hardship is addressed in the process of granting variances, conditional use permits, et cetera?
Yeah, so that's a good question. And I think to bear in mind that the unnecessary hardship factor, it attaches to the property, right? So I guess you could say, well, yeah, but you created it because you purchased the property. But, people have a right to purchase property, and people have a right generally to use property that they purchased within obviously the realms of the applicable laws, and obviously, again, the right of the jurisdiction to regulate, through the police powers. So in terms of, and again, I did mention I don't do too many variances because, to be perfectly frank, think you're right that when a jurisdiction sort of strictly applies the findings, they're fairly hard to, to satisfy. But I guess I'm just trying to think of the few that I've done, an unnecessary hardship. So trying to think of examples as I'm talking out loud here. But I guess a situation, oftentimes what jurisdictions will look at in evaluating findings for variances is, properties in the immediate vicinity of the property and sort of similarly situated properties. So again, I'm trying to think of an example off the top of my head, and I may not think of like the best example, but say you've got a whole string of properties zoned, I'll just say R60, which is a 6,000 square foot single family lot in Montgomery County. And so say you've got a whole string of properties that are R60 and people were able to build single family homes on those properties. And then there's some factor related to the lot that you've purchased or the lot that you're looking at, maybe due to like topography, it's hard to site the house within the setback requirements because maybe there's a steep slope or something like that. So, is there, something unique to this lot that is separate from the other lots in the vicinity? And would you be creating an unnecessary hardship by not granting a variance and saying, oh, okay, you could build a single family home on all of these other nearby lots, but here, just because maybe you've got a hill, right? There's a hill, and so you can only set back 15 feet from the lot line and not 20 feet from the lot line. But just because of that, is it an unnecessary hardship to say, well, now you can't build a house at all? Or should you be granting a variance and saying, okay, look, within the confines of what you're dealing with and the topography and the circumstances, it would be an unnecessary hardship to say all these other lots here were able to build a reasonably sized single family home within the development standards, but because you just can't meet this one thing, you can't build it all. So I think that's sort of where the unnecessary hardship, and again, the hardship is, attaches to the property. And I get what you're saying in terms of, well, you shouldn't have bought the land. But again, it comes back to the right of people to buy property and to use their property within the reasonable confines of the rules and regulations established by the jurisdiction.
Perfect. This next question, Mason, I think I'll throw out to you, but certainly Heather, if you have any thoughts as well, please feel free to chime in. Excuse me if I sneeze. I'm mid sneeze right now, the worst feeling ever. But this question asks, what do you think about EJ, quote, help your neighbor first policies, such as prior assistance, where a certain percentage of carbon credit exchange go to those neighbors typically that are underserved, and then given costed out of the renewable process as related to efforts such as home solar panel installation?
Sure. So this, I can answer this a couple of ways. One is to link back to the RGGI program or any sort of carbon pricing program. Another very cool thing about carbon pricing programs is that they generate revenues. I mean, that's the point, that you apply an adder or a fee to the polluter that creates a bucket of money that you can do things with. Within the carbon pricing area, it's been shown that if you take most of those funds and hand them back to, you funnel that back through the electric ratepayer, the ratepayer actually doesn't see much cost in impact associated with implementing the carbon program, and yet there's still a lot of money left over. So in Pennsylvania, current projections and the litigation is that that there will be several $100 million left over for the state to use to do cool things with, like support EJ programs or support renewable expansion or projects or electrification or home efficiency, home heating programs, lots of cool stuff that you can do for underserved communities. Another way I'll kind of answer the question is within the design of programs themselves. So talking specifically about solar, most of the, well, in fact, I'm not aware of any home solar PV program that gets as granular as this to kind of address specific mandates or requirements around EJ or historically burdened communities, but you totally can do it. You can have requirements that, X amount of projects be in, Y type of communities, or You can have projects that are located in particular communities get bonus payments and create a financial incentive. So there's just lots of opportunity here for folks to be creative about the implementation of programs. We saw in Illinois last year, there's a program that was adopted to move the state to 100% clean energy, and there are very explicit EJ requirements, as well as labor and use of unionized and organized labor requirements around new project development and even retention of existing carbon-free resources. People being thoughtful about, policymakers being thoughtful about these issues in ways that they historically haven't, which is very exciting to see.
Perfect. Two more questions that I see so far in the chat. This first one, Mason, I'll throw out to you, but again, Heather, if there's anything you'd like to add, it's about PG County specifically. So it states, PG County promised to give solar energy subsidy after 5 years, excuse me. Now it is difficult to reach them and request the subsidy. Any thought on energy subsidies in these counties? And maybe you can expand it beyond PG County too on solar subsidies or energy subsidies.
Yeah, I'm not familiar with the PG County program. I imagine that there's, just an administrative hurdle to get over. And I'll share my own story. So my project, our solar PV, home project came online in March. We are still waiting for the final certification for us to be able to actually earn the revenues associated with these environmental credits that we're generating. Process-wise, the project had to be, of course, signed off on by, home inspectors, and city inspectors and stuff like that. But then had to be registered, certified by the Utility Commission within DC, and then had to go for additional certification by PJM, that grid operator that I mentioned, because we operate within the regional grid, and PJM is the one that's keeping track of the units of production, which would then be monetized through these credits. And it's what, almost July, and our project went online in March. So these, it's administrative in nature. So, when you're dealing with folks that are managing programs and they're probably managing multiple programs, and relative priorities just becomes, important to stay on top of.
Yeah, and I'll just say, and I know nothing about the subsidy program, but I was actually just Googling, as any good lawyer knows, we do a lot of Googling. And it looks like I'm just going to tell you, not legal advice, but it looks like it's a tax credit form, and you have to actually fill out the form. And if that information doesn't help you, I would definitely recommend reaching out to your council member for your district. They are typically very responsive to their constituents. So if the tax credit form and whatnot doesn't help you and you haven't gotten anywhere, I definitely say reach out to your council member, and their information should be online, and they're typically very responsive. So that just be, hopefully that helps. Thanks, Sarah, thanks, thumbs up.
Perfect. We got one more question in, and then we have another one. This is sort of a follow-up on the EJ question. So I'll throw this out to both of you. It's really about energy and land use. It asks, in a similar vein, my home state has a large amount of brownfields, many of which occur in economically disadvantaged areas. Does the use of these areas for renewable power generation, such as building a community solar farm, have a set of regulations that they must clear due to the Superfund designation, or does it really depend on jurisdiction?
Maybe I'll just speak briefly. I would say it depends on jurisdiction. And again, I think this is an example where, I'm certainly aware of sort of the federal Superfund. I studied environmental law before I ever became a land use and zoning attorney, but where, like, for example, Maryland has its own brownfields program. And so, like, I've got a few sites that are essentially, they're dirty sites. And so as part of redevelopment, and again, I think it depends on the level of redevelopment, the type of redevelopment. Is it residential? Is it supposed to be commercial? Here, community solar farm, like, you're not, I presume, turning up the soil a lot, but I think it is going to depend on the jurisdiction, and then again depend on sort of what level of development / redevelopment you're proposing, and sort of evaluate it accordingly.
Yep, and I mean, I would just add this is another potential alignment, issue, right? That you've got one set of statutory and regulatory requirements which were adopted for, their own set of reasons, and then you want to be doing something to, make progress in another area, and they might be rubbing up against each other. We see this right now with, I mean, totally different, but the anti-dumping and countervailing duty investigation for solar panels that is ongoing under a statutory paradigm that the Department of Commerce is required to comply with, and yet she has been called up before Congress and impressed upon by Department of Energy and by President Biden of, what can you do here? That investigation is getting in the way of achieving our clean energy goals. And she's like, I'm following the law that you told me to follow. Like, you want to change the law, then, we can talk about that. And so that's my reaction to this question, is that, there may be these things pointing in different direction, conversation that would need to be had.
Excellent. And I see one more question here, and it's a question for both of you. The questioner asks, are there any local, state, or federal programs aimed at encouraging micronuclear, advanced nuclear, or floating nuclear reactors? Additionally, how have land use laws been used to regulate nuclear reactors? I know the permitting process is through the NRC, so I'm curious how local laws factor in.
I saw Mason doing a small nod, so I'll let him take over because I can't speak to nuclear.
Sure. Yeah. So I mean, there are land use would still apply. The permitting and licensing associated with operating the nuclear plant is going to be subject to the NRC jurisdiction, and so then there's going to be some interaction and relationship between the state localities and the federal government. The question is there kind of work being done with respect to advanced nuclear or kind of new technologies or new applications? Yes, definitely. Lots of work going on. Some companies doing some pretty cool development stuff, working its way through the NRC process. DOE providing lots of funding in this area. And the thing that's particularly exciting about the new nuclear technologies is the land use impact is much less significant or material. So the new reactors, much smaller in design. They're designed to be either entirely or partially underground. Most of the designs, there was mention of the floating, but the concept is of all of them of being able to contain any sort of issue in a kind of an immediate, safe way. And so, currently our nuclear facilities have a lot of land associated with them. And, we do things with it. There are parks and recreations and stuff like that. But like a lot of it is we just need to maintain security and safety around the area. And there are very specific requirements with respect to, populations in the area and distance away from the reactors. And those issues become much easier to manage with the smaller advanced reactors. And so, where you might be talking, in the 5 to 10 mile or maybe 15-mile range around a current, technology reactor, you're talking more like a mile around an advanced nuclear reactor. And so you think about the ability to site an always on, highly reliable, zero emission facility that is flexible and can be placed strategically, around and kind of close to where you need it. It's a very cool, exciting technological opportunity. You compare that to wind and solar, which needs a lot of footprint, like to match the amount of production coming off of a nuclear unit. You need, what can be in the hundreds of acres of land, and sometimes many square miles of land for a wind or solar farm. And back to that slide I showed about the build out, what we need to accomplish our decarbonization goals. The land use and water use associated with any of these technologies, whatever it is just a factor that we need to keep in mind, because we only have so much land, we only have so much water, and we need to be very thoughtful about the way that we're using it as we're reaching all of our other goals.
Excellent. Well, I don't see any more questions. So in the remaining couple minutes that we have, I just want to turn things over to both of you for any closing remarks that you might have, or closing thoughts, closing statements. So Heather, I'll turn it over to you, and then Mason, we can hear from you.
Yeah, I think it was funny. I was actually just thinking on, I think Mason's answer from 2 questions ago about where you have, competing priorities. And I think you were sort of alluding to maybe the federal level, but I was just, it made me laugh because, even at the county or city level, and I think this is probably the hardest thing that I face in my practice, is that we get, and I say we, me, and whoever I'm representing in terms of what they want to do with property, we get caught between agencies just at the county or city level all of the time, because the Department of Transportation, wants one thing, and then they want a wider road, right? Or they want the bike lane to be paved through the property. And then, on the environmental and stormwater side, they say, no, we don't want that much additional impervious. And then, you've got folks, on the permitting side who have this to say. And so we find ourselves caught all the time just between agencies, even just at the county or city level. And so it's very hard to navigate because everybody always has, their priorities. That's what their agency is designed for, and that is what they advocate for. So anyway, it was just, I don't have anything helpful to add, other than that's probably the hardest part of what I do, is just navigating the competing priorities just amongst these small jurisdictions themselves, because everybody wants everything. And at the end of the day, your clients, or you, if you're buying property, you only have so much money to accommodate everything. So anyway, just an interesting remark as opposed to anything practical to say, but it's very frequently experienced.
Yeah, well, just building off something that you said earlier, Heather, about being a problem solver, kind of along those lines, like in these areas, particularly for the newer lawyers, but it's a good reminder for all of us that we're kind of trained, and in fact often paid to be advocate for our client, right? And oftentimes being the best advocate means being a problem solver and approaching things, wanting to understand what are the competing priorities. Do we have commonality and goals? If we don't, then where is that disconnect? Because if we don't share a vision for where we want to go, then it's very difficult, to make progress. And so kind of keeping that in mind, as a touchstone, it's something that we struggle with, every day in our practice in the clean energy space, but it really applies to everything. So appreciate people taking the time today.
Yeah, same.
Well, I just want to close by saying thank you so much to our audience for joining us today and for your many thought-provoking questions. We hope you'll continue to watch this space in the years ahead. And an enormous thank you to our fantastic panelists, both Heather and Mason. We just so appreciate your many contributions to today's program and to all of your time that you've put into this. Thank you all so much again. We so appreciate you being here with us today. Please take care and stay safe. Thank you, everyone.
Thank you.
Have a great day.
You as well.